The courtroom had been loud all morning, lawyers arguing, papers shuffling, reporters whispering behind glowing laptop screens. Everyone expected another routine exchange between attorneys and the judge. But then it happened. A single statement was read aloud. 7 words tied to the name Jeffrey Epstein, and suddenly the entire room went silent. No objections. No whispers. Not even the scratching of pens. For a moment, it felt like the air itself had stopped moving. Because everyone in that courtroom understood the same thing at the exact same time. What had just been said could change everything. The hearing had already been tense long before the moment that would later dominate headlines. The case itself had attracted enormous public attention. Reporters filled nearly every seat in the gallery, their laptops open and ready, fingers hovering over keyboards as they waited for anything noteworthy to unfold. Outside the courthouse, television crews stood behind barricades with cameras mounted on tripods, hoping to capture reactions from attorneys and witnesses as they entered and exited the building. Legal analysts on news networks had been discussing the hearing for days. Some predicted a heated confrontation between the legal teams. Others believed the session would simply be another procedural step in a much larger legal process. But regardless of the predictions, everyone agreed on one thing: this hearing mattered. Inside the courtroom, the atmosphere felt heavy. It wasn't loud or chaotic. In fact, the tension showed itself in quieter ways. Attorneys shuffled through thick binders filled with documents, occasionally marking important lines with bright highlighters. Assistants moved carefully between rows, handing over notes or whispering brief reminders about exhibits and timelines. Every movement felt deliberate, controlled, and focused. At the front of the room, the judge observed everything from the bench. Years of experience had taught the judge how to read a courtroom, the subtle signals, the shifting body language, the moments when attorneys prepared to introduce something significant. From the outside, the judge appeared calm and composed, projecting the steady authority expected in a courtroom of this magnitude. The morning session unfolded slowly. For hours, the discussion revolved around highly technical legal arguments. Attorneys debated the admissibility of certain pieces of evidence. They questioned whether particular documents should be included in the official record. At times they discussed the credibility of potential witnesses and the proper procedures that should guide the next phase of the case. To legal professionals, these discussions were essential. But to most observers in the gallery, the details were complicated and difficult to follow. Legal terminology filled the room, phrases about precedent, evidentiary standards, and procedural rules that rarely appear outside of courtrooms or law textbooks. Still, the reporters remained attentive. Because even during these routine arguments, there was a sense that something larger might surface. Every now and then, attorneys would pause before referencing a document. Occasionally one lawyer would glance toward the opposing table with a look that suggested more was coming. Those small signals didn't go unnoticed by the journalists and analysts watching closely. Beneath the routine legal exchanges, something deeper lingered in the background. It was the unspoken understanding that this case existed within a much larger story, one that had already captured international attention for years. Everyone in that courtroom knew that at some point, the discussion might move toward a name that carried enormous weight. A name that had appeared in investigations, headlines, documentaries, and countless public debates. A name that continued to raise questions long after the original criminal proceedings had ended. Jeffrey Epstein. Even when the name wasn't being spoken directly, its presence seemed to hover over the proceedings. Some attorneys avoided mentioning it altogether, focusing strictly on procedural details. Others referenced related investigations in careful, measured language. But the possibility of that connection lingered in everyone's mind. Reporters knew that if Epstein's name entered the conversation, the hearing would instantly become front-page news. Legal observers understood that even a small reference could open the door to a much broader discussion about past investigations and previously examined evidence. And so the courtroom waited. Hours passed as arguments continued, documents were reviewed, and procedural matters were debated with careful precision. Then, slowly, the the moment began to arrive. An attorney stood. A document was lifted from a folder. And within seconds, the name that had hovered over the entire hearing was finally spoken aloud. No one in that courtroom expected just how powerful the moment would become. It started quietly. In fact, if someone had walked into the courtroom at that exact moment, they might not have noticed anything unusual at all. One of the attorneys slowly rose from their seat and asked the court for permission to reference a document that had recently been added to the official record. The request itself sounded routine. Lawyers asked to reference documents all the time during hearings, and most of the time those documents simply support arguments that have already been discussed. The judge looked down briefly at the case file, then back up toward the attorney. A small nod followed. Permission granted. The attorney stepped away from the table and walked toward the podium at the center of the courtroom. In their hand was a thin folder, plain, unremarkable, and almost ordinary compared to the thick stacks of binders that had been spread across the legal tables throughout the morning. There was nothing dramatic about it. No bold labels. No visible markings that suggested it contained anything extraordinary. At first glance, it looked like just another exhibit among the hundreds of documents already filed in the case. But as the attorney placed the folder on the podium and slowly opened it, something in the room began to shift. It wasn't a loud change. No one spoke. No one interrupted. Yet the atmosphere subtly tightened. A few people in the gallery leaned forward in their seats. Reporters who had been typing steadily on their laptops paused and lifted their heads, sensing that something different was about to happen. Even members of the opposing legal team, who had been quietly organizing papers and whispering to assistants, stopped what they were doing and looked up toward the podium. Moments like this are familiar to experienced courtroom observers. Sometimes, the smallest gestures signal that an important moment is approaching. The attorney adjusted the papers inside the folder and cleared their throat before speaking. Their voice was calm and measured, echoing slightly through the quiet courtroom. Your Honor, the attorney began, this document contains a previously recorded statement connected to the broader investigation surrounding the matters currently before the court. The phrasing was careful, precise enough to maintain legal clarity but vague enough to avoid revealing too much too quickly. The judge leaned slightly forward. From the bench, the judge asked a straightforward question, the kind that courts rely on to keep proceedings focused and relevant. Counsel, the judge said, is this relevant to the matter before the court? The attorney continued reading slowly so the court reporter could capture every word accurately. Several sentences passed. Then the tone changed. The next line was shorter. Much shorter. A single sentence. Direct. Clear. Impossible to misunderstand. And within that sentence appeared a name that carried enormous weight. Epstein. The moment the name was spoken aloud, something unusual happened. The room fell completely still. Pens stopped moving. Keyboards went silent. Even the quiet rustling of papers seemed to disappear. No one interrupted the attorney. No one objected. No one even whispered. For a brief moment, it felt as though the entire courtroom had frozen in place. Because everyone present, lawyers, reporters, observers, and even the judge, understood that the single name just spoken had the power to change the direction of the entire hearing. The attorney read the lines slowly, carefully pacing each word so the court reporter could capture the statement exactly as it was spoken. In a courtroom, precision matters. Every sentence becomes part of the official record, and even the smallest detail can later carry legal significance. As the attorney continued reading, the statement began referencing information allegedly connected to the network associated with Jeffrey Epstein. The language was cautious and structured, typical of legal documents. It did not make sweeping claims or dramatic accusations. Instead, it suggested that certain individuals and events mentioned in the current case might overlap with elements previously examined in earlier investigations. The wording was careful. But the implication was unmistakable. The moment those connections were hinted at, something in the courtroom shifted. Suddenly, the room felt different. The quiet that followed wasn't the normal silence of a courtroom waiting for the next sentence. It was deeper, heavier. For a brief moment, the only sound anyone could hear was the faint hum of the overhead lights and the distant whir of the building's ventilation system. Later, one reporter who had been sitting in the gallery would describe the moment by saying it felt like the entire building paused. From the bench, the judge leaned slightly forward. It was a subtle movement, but in a courtroom every gesture carries meaning. Judges often remain physically still while attorneys speak, maintaining an expression that reveals very little. But that slight forward lean suggested careful attention to the exact wording being read. At the counsel tables, opposing attorneys remained motionless. No one interrupted. No one objected. That alone was unusual. In heated hearings, objections tend to come quickly and frequently. Lawyers often challenge the phrasing of statements, question whether something is relevant, or argue that a particular line of discussion should not be allowed into the record. Interruptions are a normal part of courtroom exchanges. But here, nothing. The silence stretched for several seconds. And inside a courtroom, several seconds can feel much longer. Reporters sitting in the gallery stopped typing. Pens hovered above notebooks, waiting. Even experienced legal observers seemed unsure whether the statement would trigger an immediate response. Yet the stillness continued. Finally, the judge broke the silence. The voice from the bench was calm, measured, and deliberate. "Counsel," the judge said, "are you asserting that this statement directly connects the issues in this case to the prior Epstein investigations?" It didn't accuse the attorney of making an unsupported claim, but it clearly demanded clarification. Courts must be cautious whenever references are made to other investigations or unrelated proceedings. Judges have the responsibility to ensure that anything introduced into the discussion is legally relevant and not simply speculative. All eyes turned toward the attorney at the podium. The lawyer paused briefly, choosing words with visible care before answering. "Your Honor," the attorney replied, "we are asserting that the statement raises questions that may be relevant to the credibility of certain testimony." The response was deliberate. It did not claim a direct connection. It did not accuse anyone of wrongdoing. Instead, it framed the statement as something that could potentially affect how certain evidence or testimony might be viewed. But that careful wording only seemed to deepen the tension in the room. Because while the answer avoided dramatic conclusions, it still suggested that the statement could influence how key parts of the case might be interpreted. In other words, the line that had just been read might not end the argument. It might only be the beginning. And everyone in that courtroom understood that the discussion that followed could determine just how far that single statement would reach. The judge paused. From the outside, the pause might have looked brief, just a few seconds of silence from the bench. But inside the courtroom, it felt much longer. Everyone watching could sense the careful calculation taking place. Judges are trained to move deliberately, especially when a statement carries implications that could stretch far beyond the immediate case. And this was clearly one of those moments. Behind the bench, the judge reviewed the situation with quiet focus. On one side, the statement carried obvious public interest. Any reference connected to Jeffrey Epstein instantly draws attention. The scale of the investigations tied to his name, along with the many unanswered questions that have surrounded them for years, means that even the smallest mention can quickly dominate headlines. The judge understood that. Everyone in the courtroom understood that. But the courtroom is not a press conference or a news studio. Courts operate under very different rules. On the other side of the equation was the law itself, specifically the responsibility to ensure that only relevant, properly supported information influences a case. Judges must constantly guard against speculation, implication, or public curiosity shaping the direction of legal proceedings. No matter how intriguing a statement may sound, it cannot replace actual legal evidence. That balance, between public attention and legal discipline, is one judges face often in high-profile hearings. The courtroom waited as the judge considered the next step. Then, after a moment, the judge spoke again. The court will review the document before determining its admissibility or weight. The words were calm, neutral, and carefully measured. It was neither a rejection nor an acceptance. Instead, it was a procedural safeguard, a way of slowing the moment down so the document could be evaluated properly within the rules of the court. Yet even though the response was cautious, something had already changed in the room. The impact of the statement had already been felt. Quiet whispers began to move through the gallery. Reporters who had been silently observing only moments earlier suddenly began typing rapidly, their keyboards clicking as they captured every detail while it was still fresh. Some leaned toward colleagues to quietly confirm what they had heard, making sure the wording was accurate. In the back rows, a few legal analysts exchanged quick glances. Those small reactions said a lot. Experienced observers know that courtroom moments like this don't always arrive with dramatic arguments or raised voices. Sometimes they arrive quietly, through a document or a carefully phrased sentence that introduces a new angle into the case. And that appeared to be exactly what had just happened. Because even though the judge had not ruled on the document yet, the fact that the statement had been read into the conversation meant it now existed within the broader context of the hearing. That alone could trigger deeper scrutiny. Attorneys might revisit earlier testimony. Analysts might reconsider timelines or connections. Reporters would certainly begin examining how this statement fit into the larger narrative surrounding the case. In many trials, pivotal moments come from dramatic witness testimony or surprise evidence. But sometimes cases pivot on something far smaller. A single line buried in a document. A single connection raised at exactly the right moment. A sentence that forces everyone involved, lawyers, judges, reporters, and observers, to pause and reconsider what they thought they understood. And this particular line had the potential to do exactly that. Because once a statement enters the courtroom record, it can travel far beyond those walls. It can shape questions. It can influence investigations. And in some cases, it can expand the entire conversation surrounding a case in ways no one fully expected. After the hearing ended, the exchange quickly became the focal point of conversation far beyond the courthouse steps. Within minutes, reporters were broadcasting live updates. Legal commentators began dissecting the moment on television panels and podcasts. Clips of the exchange circulated online, accompanied by headlines highlighting the sudden reference to Jeffrey Epstein and the judge's measured response. For some analysts, the legal significance of the statement remained uncertain. They argued that without direct evidentiary support, documents, verified testimony, or clear procedural linkage, the statement might ultimately carry little weight. Courts, after all, are governed by strict standards. A reference alone does not establish relevance. A connection implied is not the same as a connection proven. From this perspective, the moment may have been dramatic in tone but limited in legal impact. Other experts, however, saw something more. They pointed out that even raising the connection in open court could influence the trajectory of the case. A statement entered into the record can lead attorneys to re-examine timelines, reconsider witness credibility, or pursue additional discovery. It can open the door, carefully and procedurally, to new questions that had not previously been asked. And in complex cases, new questions can change everything. The debate continued for days. Some commentators emphasized judicial caution, praising the judge's decision to review the document before assigning it any evidentiary weight. Others focused on the broader implications, noting that high-profile names carry influence whether courts intend them to or not. But despite differing opinions about its long-term impact, nearly everyone agreed on one thing. The moment itself was unforgettable. Because real courtroom drama rarely unfolds the way it does in movies. It doesn't usually come from shouting matches or theatrical gestures. It doesn't always involve surprise witnesses bursting through doors or explosive confrontations between attorneys. More often, it arrives quietly. Through a single sentence. A single reference. A carefully phrased line read into the record at precisely the right, or perhaps the most unexpected, moment. What made this moment powerful wasn't chaos. It was stillness. When the Epstein statement was read aloud, there were no raised voices. No immediate objections. No dramatic outbursts. Instead, there was silence. The kind of silence that spread slowly across a room. The kind that causes people to stop typing, stop whispering, stop moving altogether. It was the silence of recognition. Recognition that something significant had just entered the conversation. Recognition that even if the statement never reshaped the legal outcome, it had already shifted the atmosphere of the hearing. For those who were in that courtroom, the memory of that silence will likely last longer than any procedural ruling that followed. Because in that brief pause, between the reading of the statement and the judge's response, everyone present felt the same thing. A sense that the direction of the case might be changing. Or at the very least, expanding. And whether that statement ultimately alters the outcome of the proceedings, or quietly fades into the background of legal procedure, one fact remains undeniable. For a few unforgettable seconds, the courtroom was united in complete, breathless stillness. It was the moment the entire room stopped breathing. Thumbs up if you enjoyed this story. Don't forget to like, share, and subscribe to the channel for more fascinating courtroom moments and legal stories you won't hear anywhere else.